Hello, everybody, and welcome to the Morning Energy Show. Today, I'm going to be going over a case between Sunder and Freedom Forever. This case is pretty important to me because it affects a lot of my friends and a lot of businesses and how they draft contracts in the future. Hopefully, this case is something that the industry can learn from or understand, so that when they're drafting contracts with their own employees or with their own partners, they can have a clear and more refined understanding of how it works. So, thank you for participating in this with me. I hope it's very helpful for you. I want everyone to know this case is not over yet. The final decision is set to be made later this year. While I don't know the exact date, I have been told it will likely occur in May or June. The reason I'm bringing it up now is to bring attention to the possible outcome that could affect many. I'm not advocating for one side or the other. As many of you know, I very much enjoy the solar community and all it stands for. I have been a proponent for the success of any individual or business. I see value in each entity's culture, practices, and offerings to their clients and their sales teams. As you read through this document, you will see useful terms, timelines, and excerpts from the document that have been made public. None of the content in this document has been fabricated. For clarity, each source I have referred to comes from the legal documents that either the court has stamped or my attorney has summarized. I do not consider myself an authority on legal matters. Admittedly, I did hire my attorney, Jon Dodart, to interpret the court stamped documents for me. That said, I did read through the documents and studied them in full. Because I am drafting this document, I will share some of my feelings on occurrences listed in the stamped court documents. And I will tell you, it brings back some hard lessons, very much some hurt feelings, and a loss of trust I've experienced in my career. Jon, thanks for joining me.
You're welcome. And Jake, first and foremost, thank you for reading the legal disclaimer that I asked you to prepare in this. But it was sincere and true. And I appreciate the time that you've spent in going through the documents with me and learning about what's taken place.
Well, I'm doing it because I'm scared out of my mind to go over this. But I have studied it for at least 2 weeks. So
Yeah.
I'm confident that I understand it in full. And I do thank you for being on here with me to make sure that everything's set appropriately for the audience so that my bias isn't necessarily put into these documents as they're written. In fact, we're going to create even a higher level of transparency for you. We're going to provide every slide that we go through in this document. We're going to provide the court stamped documents. Jon, correct me, it's the bond, it's the chancery stamped documents, the Supreme Court documents, and is there anything else I'm missing?
Yeah, there's also a subsequent order on, there was a motion to amend the bond. So it's a subsequent court's decision on that order.
Okay, and then Sean, can you come up on stage and tell everyone where they can find these links to download all of these documents?
Yeah, hi. You're going to find everything that you need about this case on themorningenergyshow.com/Sunder-Freedom.
Thunder or Sunder?
Sunder, S-U-N-D-E-R.
All right, cool. I thought I heard the thunder. We're bringing it here now, though.
Yeah, so themorningenergyshow.com/Sunder-Freedom.
And if they don't remember that, is it going to be placed anywhere? Is there like
It'll
a
be
link
in the notes down below here. Anywhere you're listening, it'll be in the notes. Yep.
We want full transparency on this. We want you to go through the documents yourselves. We're not trying to hide anything or pivot one way or another. This is what is literally, the interesting thing here is these were literally written by the judge, and I cannot believe some of the things that were put in this document and the way that they were worded. Jon, have you ever seen anything like this?
Well, like you
Thank you,
said,
Sean.
there's a lot of very strong verbiage used by both the Chancery Court in Delaware, which is kind of like a trial court, and in the Supreme Court's finding, the Supreme Court of Delaware. It is rare that courts choose such strong language. They usually try to create more neutral language, but as we'll see, if you didn't read it for yourself, you might not believe that it was written that way. So I'm really glad that we're making that available for everyone that watches this so they can read it and see the same thing that we did.
All right, so here we go. I'm going to go ahead and start this process for all of you to experience what is happening in this court document. So you'll notice over on the right-hand side, we've actually taken the exact page from the document, and we're going to go through and talk about it with you. I am not great at legal stuff, so after studying this for 2 weeks and hearing John's side, I did word it in a way that hopefully you all can understand it a little bit better. But my interpretation of this is not to be understood as fact. You're to go through these documents yourself, and that's why we made it available to you all. So here we
And,
go. Oh, go
and
ahead,
Jake,
John.
just so they know, basically what we're reviewing on the right-hand side was the Chancery Court's opinions in order. And so as they're going through it, they should know that eventually this came before the Supreme Court, which we'll discuss later on as well.
All right. Thank you for that, John.
Mhm.
So Sunder was created in August of 2019. They had signed an exclusive agreement for 5 years with Freedom Forever. That exclusivity ended in September of 2023. And we're going to go over some of what the exclusivity was. And I even have some words on Sunder being created in August 2019. We'll get to that when we start to talk about legacy. But Tyler Jackson, that's a name that you're going to hear a lot here. And I've heard from many in the industry that this man is very likable. I haven't met him myself, but I'm told he's liked by many. And you'll see that there was a big fight on a tug of war of who gets to retain him and who doesn't.
Must be nice.
Must be nice. That is correct. Tyler Jackson, if you're watching this, I look forward to meeting him. In the summer of 2023, Freedom's principals encouraged Jackson to join Solar Pros. And it took me a minute to figure out what principles was. That is basically the leadership at Freedom. Is that correct, John?
Yeah, that's typically how the word principles is used in that, correct?
All right. Between September 11th and 19th, 9 of the 12 regional managers, regional managers, and co-regional managers who reported to Jackson also joined Solar Pros. Over 300 sales personnel followed them, according to this stamped court document. And if anyone's in the solar industry, I'm sure you could all appreciate that 300 people coming over would be a celebratory day. That is a big day. 300 sales reps. Okay, none of the managers or sales personnel have any restrictions on their ability to work for a competitor or to solicit Sunder personnel. That becomes important for those 300. However, you'll find out here soon that the leadership did have some restrictions, and that's what created this entire case here. So September 22nd, 2023, Jackson officially signed on with Solar Pros. On September 25th, Solar Pros announced that Jackson had joined as its new president. So just about 3 days later, Sunder maintains that Jackson was bound by restrictive covenants. Now, while those 300 in this document, it states that those 300 necessarily weren't constricted, it does look like that Jackson was. He received incentive units, and many of you have probably received incentive units if you're a manager level or above and you've worked for a large organization. It is one way that they like to tie you to the organization for longevity, because no one wants to lose their volume when they're growing or they're having their business valued. So he received incentive units from Sunder. Sunder's attorneys embedded a set of restrictive covenants that binds Jackson. So what are these binding covenants? And John, feel free to interpret these in your way if you feel like they can, if they need a little bit more to them. But a restriction prohibiting the holder from engaging in any competitive activity. A restriction prohibiting the holder from soliciting Sunder's employees and independent contractors. A restriction prohibiting the holder from soliciting, selling, accepting any business from or engaging in any business relationships with any of Sunder's customers, and a restriction prohibiting the holder from inducing, influencing, causing, advising, or encouraging any Sunder stakeholders to terminate its relationship with Sunder. John, good so far? Pretty clear?
Yeah, pretty clear. So the 4 restrictive covenants that they put in, obviously these are kind of summarized as to what they were. But if you're looking at just these 4 covenants that came in later on, as we're going to discuss, you can kind of summarize them as a competition restriction, as the court has noted here, personnel, customer restrictions, and stakeholder restrictions. Those are kind of the 4 general ways to look at the 4 main restrictive covenants that were listed into the contract.
Thank you. All right, so here's where it starts to get interesting, and this is, where some of my hurt feelings from the past start to come in. Each covenant applies not only to the holder of the incentive unit. So if in this case they're talking about Tyler Jackson got these incentive units, but also to that person's affiliates, defined to include the holder's spouse, parents, siblings, descendants, both natural and adopted.
That's pretty broad.
That's what the covenant thus purport. Is it purport? What is that word,
Purport.
John? What does that mean?
Yeah. So basically, the court is saying, well, it seems like these covenants are intended to bind Jackson's wife and children. The court's kind of interpreting the broad nature of what these covenants were intending to apply to, or could be applied to.
The covenants apply during the period when the holder owns the incentive units and for 2 years afterward. Remember, that's 2 years. That's going to come up here pretty soon. A holder has no ability to transfer the incentive units, but Sunder can repurchase them for $0 if the holder is terminated or leaves other than for good reason.
Yeah. So, and again, Jake, we're right now, before we get too far in depth on this, we're kind of taking a high level overview of what's going on in the case, what generally these restrictive covenants were. And the reason why I say that is the timing of a lot of these things and what took place in the formation of these restrictive covenants. That's really going to matter in a minute. But again, generally looking at some of these things, I know that you've experienced that in reviewing a lot of your contracts. Some of these very restrictive terms, saying that you have no ability to transfer your incentive units, especially where in some of these instances, you've been there from the very start, either as somebody who helped form the businesses or helped create them. And obviously that comes into play with Jackson's understanding, as we learn later on.
So because Sunder can decide not to repurchase the incentive units, the covenants could be perpetual. Now, I want everyone to notice these are not my words. These are not summarizations. These are literal screenshots from the document itself. So if you're listening to this thinking, notice that these are actual screenshots on the document to the right. This is what the court understands it to be. This is what they're going to find in the final trial. So because Sunder can decide not to repurchase the incentive units, the covenants could be perpetual, meaning they just last forever, essentially.
And Jake, just to clarify, just because you said in the final trial, this is just what they're summarizing in the overall factual document before they come to their final opinion, is I believe what you meant to say. But
thank you, John.
Just to be clear on
that. That is why I have my man on here.
We need one of those little flags that legal can wave in the background, right? They just flag you down every now and then. So forgive me for our viewers that are watching on this if I interject every now and then. I just want to clarify a couple of things.
Incentive units serve as a form of incentive compensation. That's given. Okay, thank you. Many jurisdictions outside Delaware have strong interest in regulating employee compensations and the enforceability of those restrictive covenants. That becomes important a little bit later, and why Delaware is such a big state in these matters. Sunder is headquartered in Utah, is subject to the state's regulation on such matters, while Jackson is residing in Texas, is affected by Texas law on earning a living. Oh, my goodness, I can't speak right now. Good thing it's up there in writing. Freedom is based in California, and Solar Pros is based in Nevada. Also operate under the respective state regulations. Sunder filed its lawsuit in Delaware because it is a Delaware LLC using legal strategies to enforce restrictive covenants under Delaware's contractarian laws. John, what are they referring to when they say legal strategies being filed?
Yes. So when you're looking at what court to file in, often as an attorney, when a dispute arises, we want to know, is there some kind of choice of forum and choice of law clause listed in the contract or in the agreement? Different states interpret different clauses in different ways, right? I know that's kind of a generality, but for example, some clauses are enforceable in California that other states say, no, we're not going to allow that. And that was one big predominant issue that the court noted in their findings and opinions was, it's interesting that they decided to bring it in a Delaware court as maybe opposed to a Texas court where Jackson lived, or in a California court where Freedom's headquartered. And instead, they chose to litigate this in a Delaware court. So now Delaware has to then determine what laws are we applying? Are we applying the laws of Delaware? Are we applying the laws of Utah, of whatever state may be? And how does a Delaware court interpret those with the overall like glasses that they're going to view these things through, or the lens from a Delaware court? So in this matter, where Sunder is a Delaware corporation, they did decide to file in Delaware for this lawsuit.
And we're going to tell you guys some interesting stuff is coming up. And if don't get off now, because I'm telling you, you got to stay on and hear the things that are coming and how Delaware feels about it. So here we go. Delaware courts have increasingly been asked to rule on restrictive covenants, covenant disputes affecting businesses globally, including cases involving Hong Kong, Italy, and so many parts of the United States. This document lists all of them. But Delaware's a little bit hesitant to take these on because they in the document it says like, man, if we decide this, then it could contradict what Utah does, and we don't want to do that. I think later on it even says we prefer if they be handled in other states, but too bad for us, it's here, and so I guess we have to do it. So
yeah, courts don't like interpreting other states' laws. They don't like to have to do that. Judges especially don't like to have to do that. They will, of course, if they're required to based on a filing or whatever else. But typically, they like to have the state in which the issue is really arising, or the laws of that state should be applied. They like that to be tried in those states where those judges that know those laws, perhaps more in depth, can apply them. But as you know, many companies file in Delaware, and so this is not uncommon. They file their registration in Delaware, so it's not uncommon for a Delaware court to have to interpret other states' laws or contracts.
yeah, I didn't know that until this whole case. I didn't know that a lot of companies do it. And when I asked around, John, correct me if I'm wrong, but the reason companies want to do it in Delaware is because their court systems, their judges, everyone in there understands legal documents better than anywhere else in the country. Even different parts of the world bring it to Delaware or file in Delaware because of their understanding of contract law and business. Is that right?
Um, Arguably, yes. Delaware tends to be a very favorable state for corporations, and that's why most people file there. The court systems in Delaware tend to have a lot more focus on businesses, and not just necessarily Delaware businesses, but even like nationwide. They understand generally how businesses operate, and they have judges that I think are a little bit more skilled and in tune with contract law. And so, yeah, that's why a lot of businesses will file there, besides obviously favorable tax benefits, things like that.
Okay, so yeah, here as you can see, Delaware courts face challenges in addressing these matters because their authority relies on other states deferring to Delaware law for corporate governance. If Delaware allows its entities to override other states' laws through internal governance documents, it risks losing the deference. The Court of Chancery lacks the resources to handle restrictive covenant disputes for Delaware entities worldwide. Its primary role is to resolve internal governance disputes, but the increasing number of Delaware's chartered entities adds to its caseloads. The reason these notes are on here is because over to the right, it's summarizing what these legal words are saying off into the right from that court document itself. Between 2017 and 2022, the number of Delaware entities grew from 1.3 million to over 1.9 million, with continued growth expected. The court's expansion to 7 judges in 2018 addressed immediate demand, but was not long-term solutions for future case growth. This doesn't have much to do with the case, but it is in the document, so I didn't want to go past it without you guys knowing it. You'll notice that as we go through this, there's going to be some that we kind of fly through because it doesn't have much to do with the case, but they're putting it in these documents. But here's where it becomes interesting. In an ideal world, now remember, this is what the Chancery Court wrote and what the judge stamped off on. In an ideal world, this case would have been filed in Utah, Nevada, or Texas, but the case is here and it must be decided.
Yeah, and Jake, it's interesting as well where they chose to file, and the court does discuss this, but there would have been advantages for both parties to have the matter filed and heard in
Yeah.
different states. And instead, they kind of chose this hybrid Delaware court to hear some of these issues. And the court
Mhm.
addresses that, which is really interesting. They don't normally address the fact that one party might have done better on different issues in a different state.
All right. So Sunder's application for a preliminary injunction against Jackson. Before we go on, John, what's an injunction?
So, typically speaking, as a plaintiff, right? So in this matter, Sunder's the plaintiff, meaning that they're bringing in action, that something is going on where Sunder says this isn't right, or we need to protect our interests. And so Sunder's trying to do something to protect that. Normally, they will file for like a temporary restraining order, right? Something that will stop the other side from doing something, either permanently or temporarily, so that this issue can be heard before a court and determined. And the argument is that if they're not stopped, then the plaintiff argues, well, we will be harmed and our business interests will be harmed, and it's irreparable. So the court needs to stop it right now, at least temporarily, and hear what's going on so that we can protect our interests and not suffer those additional damages. And so in this matter, yes, Sunder was applying for an injunction, basically trying to stop Jackson and Freedom from doing things that they claimed would be harmful to their business and irreparable if the courts didn't grant them an injunction stopping these other people from doing that. That was their claim.
Sunder's application for a preliminary injunction against other defendants for tortiously interfering with the covenants is denied for a lack of an underlying breach of contract. This ruling does not mean that Sunder cannot prove any claims or receive any remedy. Sunder might have non-contractual claims that it could prove against Jackson for the actions he took before resigning. And Sunder might not be able to recover damages if it proves those claims. But Sunder cannot obtain the preliminary injunction it seeks. They're just saying, nope, denied.
Yeah, and obviously the court goes into their basis for why, which is what we're going to discuss now. But that's correct. When the court reviewed these things to determine whether or not an injunction was reasonable to both parties, not just Sunder, but to both parties, the court did not find that Sunder met the threshold to grant an injunction. That's correct.
So the facts presented are based on the preliminary injunction record, including documentary exhibits and deposition testimony, though final trial findings may differ.
Yeah, and Jake, I do want to address that. So we obviously are relying upon all of the opinions that have been released from the Chancery Court in public documents.
Mhm.
And so we're relying upon what they found in the documents that were submitted to them. And that could have been the limited discovery potential prior depositions, as we later learn, emails, text messages, things of that nature. So we ourselves are not saying we have reviewed the deposition testimony. We're relying on the court's opinions on having reviewed the evidence that was submitted to them.
Yeah, and for everyone listening, what happened was a deposition, because I have learned all of this stuff, and it's kind of silly. I'm 42 years. I have known about it, but I didn't learn about this stuff until like 5 years ago. I was in my mid 30s when I started understanding what these terms were. I'm not afraid to admit it. I wasn't a legal person. I didn't even need legal counsel at that. I mean, maybe a little bit before that, but a deposition is basically it's like you see in the movies. They have a recorded camera. Someone is sitting in there, usually with their attorneys, and telling what to say and not say, but they're going over everything as they understood it. So you'll find out that when Sunder split apart from Legacy, all those leaders that were taken away from Legacy, they gave a testimony basically of their understanding of things that have occurred, and that's in a deposition. Also, you'll find out later that emails were submitted to the court, text messages were given. So this document, although we don't get to see all of that stuff, like John said, we have to trust that the court reviewed all of that stuff and placed a lot of that content inside of this document.
Yeah, I mean, the court actually is citing to what they believe to be the most relevant information from the evidence that was submitted. And so they specifically reference and quote it, and then they, in their footnotes, cite, wherever it's coming from. And so this isn't just made up facts for the court either. They're citing the document with specificity as far as where the information came from.
Correct. So citations in the case reference exhibits submitted by different parties, including Sunder, Freedom, and Jackson, as well as deposition transactions. The parties' inconsistent formatting of this part is interesting to me. Inconsistent formatting of text in the emails, particularly in time zone differences, made reviewing the records unnecessarily difficult. So that means probably true to sales reps' nature, myself and some of the other people I know. Like, I don't want to go through all of my text messages and emails for the history that this case is like wanting to look back at and change it to one specific time zone. They basically took all their screenshots, text messages, emails, everything they had, and they all submitted it to the courts from Texas, California, like all these different states, Utah, all these different time zones. And the court was like, hey, can you guys please come to a stable understanding or a neutral understanding of what these time zones are? And all of them were like, nah, you guys figure it out.
Well, so keep in mind, one thing that we always advise clients when we're looking at litigation or in litigation is that everything is expensive. Time is expensive. So think about whatever the court had submitted to them as far as emails, texts, having to correct the time zone, and it would have been to literally amend and note on the side what the actual, Delaware time zone in relationship to Texas or Nevada or California, wherever the texts were coming from. I mean, that would have been a substantial amount of time. So whether it was strategic or whether it was, cost savings, or whether, the attorney just go, we'll just we'll just kick the can. That would have proven to be very difficult and expensive and timely. So it sounds like they just kicked the can to the judge, and the judge wanted to kind of call them out on, hey, thanks a lot for making me do extra work.
Yeah. Sunder's emails and texts use Greenwich Mean Time, but only the top email in the chain followed this format, requiring manual time zone adjustments. The defendants and Jackson used different timing conventions, further complicating the review process and creating inconsistencies across the records. The court found the inconsistent time formats unhelpful. That's a funny word. And suggested that in future cases, parties should agree on standardized format to ensure efficiency. Now,
So
these are
Jake,
not screenshots. These are summarizations from over there. So these are, you'll notice when they're screenshots.
but also I want to point out the fact that when the courts use a toned down word like unhelpful, but then in other places in a brief might use a more I guess abrasive or aggressive verbiage. It's really interesting to contrast that, right? Because if a court says like, hey, that was really unhelpful, that's really them being like, hey, this really was frustrating and dumb, and knock it off because you're giving me more work. But when they use even more aggressive language or verbiage, you have to really escalate that in understanding how a court writes its opinions. And so you see that kind of throughout. Different things they're more subtle on, and in other areas they really blatantly use very strong verbiage.
Yeah, you'll see that in the screenshots. And just a reminder, these are summarizations. The unhelpful word might have come from my summary. I
Yeah,
can't
correct.
attest to the fact that it's actually written in the document here, but the screenshots are written in the document, and we'll point those out. All right, so here we're going to get into some interesting things with legacy now, and it does hold some relevancy as to what's happening here. There's some lines in there where you'll see the things as drips with irony. That's an aggressive one that I couldn't believe the court put in there. But these are the people that broke off of legacy, and you'll find out why it's important. They labeled it as Sunder's beginning. Eric Nelson, who I believe we'll find out here in a minute, was the CRO. Is that right? He was the chief revenue officer over at Legacy. Max Britton, Tyler Jackson, Steve Cohen, Michael, Jed, and Max. These guys were all at Legacy, and they ended up breaking off. They consider themselves the founders of Sunder. So that list right here, I'm going to go back. These are considered the founders of Sunder, and that's really important to note. So they're saying in here the co-founders left a different solar sales dealer named Legacy Power. All were in sales. Nelson had been Legacy's chief revenue officer, effectively its head of sales. Britton had been a vice president. Jackson, Cohen, you'll have to forgive me if you're listening to this, Michael, but it's Gutschmidt, as I would say.
Yeah.
And Sewell Ganley, were regional sales managers. So when they formed Sunder, this is a screenshot. When they formed Sunder, the co-founders agreed on an equity split. Each regional sales manager would receive 8% for a total of 40% stake. So all except Eric and Max below, they received 8%, and that total equaled 40% when they split apart from Legacy. Now, it's funny, I use the phrase split apart because if you Google search what Sunder means, it does mean to split apart. I think that was an interesting name. Like to me, if I was, I don't know, I don't even know if I can say this. I'm going to stop the legal stuff, and I'm just going to say, for me, to choose a name that kind of pokes fun at the company that I'm leaving, that I split apart from them, I don't know. I would say that it's a bit classless. You affect that company, the families, all the people, the relationship that you had built with them over all the years that you work with them, just to kind of toss it in someone's face like that. I mean, get creative. Go find another name, something that actually means something to you for culture. To build a culture off of that, off of a name, off of that, that's interesting to me.
Well, and obviously that's our understanding of where Sunder came from. Who knows? Maybe they took like the Latin translated meaning of something. We don't know, but I
That's
would
okay.
agree.
That's
I was not aware though that that's what Sunder meant when you looked it up.
Yep. So here's the founders again, and here's a screenshot. Nielsen and Britton would own the rest of the equity, giving them 60% majority. The co-founders envisioned that they would all own the same type of equity. There's different types of equity out there, but they all envisioned when they split apart that they would all own the same type of equity. There were no discussions of separate types of equity or different rights or obligations. Please remember this. They
Well,
all
and Jake,
assumed it would be the same equity. Go ahead.
I see a lot of contracts in this industry, especially with new companies that are forming or new partnerships. And I would say that exactly what all of these individuals were thinking at the very start would be exactly what I would have even interpreted as an individual, which would have been great. I'm going to get 8% of the business. We're all going to be treated the same. I would have assumed that we were all receiving the same equity stakes and rights and remedies. And it sounds like that was Jackson's understanding and some of these other parties' understanding as well, at least at the initial outset.
Thank you. The co-founders thought of themselves as partners, and they called themselves that. That's another screenshot from the court stamped documents. September 23, 2019, Legacy sues the co-founders. That list that we showed you earlier. The co-founders reached out to Snell and Wilmer, another attorney, lawyers, and regarded them as their lawyers. John, I put that regarded in quotes.
Yeah.
I don't know the relevancy. Why wouldn't they just say they hired them? Why do they regard them?
So the co-founders get Snell and Wilmer. We understand this through the legal documents, right? So in this dispute with Legacy, Sunder gets Snell and Wilmer to represent these co-founders in their individual capacities as well. And so as a lawyer, when you have a client, they become your client. And if another company was to hire me to represent individual members of a company, you have to be very clear in who is the client. Am I as an attorney, am I representing the individuals or am I representing the company's interests? And that matters later because when Snell and Wilmer also create some of these amendments and agreements to their contracts, it would be very easy for an individual to believe that Snell and Wilmer, the attorneys for that law firm, would be also representing them on an individual capacity. And so that confusion, as far as regarding them as their lawyers, would come into play because, as you know, Jake, you rely on your attorneys. That attorney-client relationship is very sacred, and so for them to understand that these were their attorneys, but maybe they weren't their attorneys, they were the business's attorneys. That's a very different thought process, and that's why I think the court is really stressing that that opinion that they regarded them as their lawyers.
Here's where it starts to get super fun. Legacy claimed that Britain's compensation included restricted stock units with 2-year restrictive covenants. Now, if you remember at the very beginning, Sunder's lawsuit against Tyler Jackson says that he breached a 2-year restriction on those incentive units that he were given. So here's Max again let's see. Legacy claimed Britain's compensation included restricted stock units with 2-year restrictive covenants. Same exact thing. So let's keep going. When Britain learned that the restrictive covenants, he had an understandable reaction. 2 years is a long time not to compete in the very industry I have bet my family's future on. This is what I have been doing for close to a decade. This is my career. And the judge wrote, this seems very heavy, or sorry, I don't know if the judge wrote this, could be Max's quote still.
This
This
is still
seems very
Max's quote.
heavy-handed. A 2-year non-compete is nuts.
Yep. And I think, and I'm pretty sure that's Max's statement there. I don't think that's the court by any means. It's still in the same quotation block. But to state that, to use his own verbiage, a 2-year non-compete is nuts. And this seems very heavy-handed. There's that level of contradiction and irony, which the court continues to pick up on. And even though Legacy is not involved in this specific lawsuit, it is referenced in the lawsuit itself with Sunder and Freedom, and brought in here to show the discrepancies. Right? It's you're arguing this point on the one side, and then you're trying to argue it in the inverse in your own case. So the court picked up on that irony.
It gets better. It gets intense. All right. So Snell and Wilmer, the attorney, wrote back. So this is the attorney that they regarded as their lawyers. Great initial thoughts. Thanks. We agree that this seems extremely heavy-handed. We are looking at the reasons these agreements might not be enforceable. So when Sunder split apart from Legacy, Legacy sued them and said, hey, we have 2-year restrictive covenants. And Max was like, wait, that's way too long. And the attorneys that Max hired said, yeah, we agree with you. We're going to see whatever we can do to make these unenforceable.
Well, and again, when you're creating a restrictive covenant or some kind of like non-compete created in terms that people are very familiar with, you have to look at the timing of how long these restrictive covenants are in place. Timing is very, very important to determine whether or not these things are enforceable. And a court will say, hey, is it reasonable to take somebody out of an industry that they've done as their career and to keep him out for 6 months, a year, 2 years, indefinitely? A court has to look at that. And so now we see here that this is one of the original co-founders' opinions, saying that a 2-year restriction is heavy-handed and nuts, right? And their attorney kind of saying, yeah, we can see that, and we're going to look into reasons why this might not be enforceable. So all of this is foreshadowing what's about to happen.
So the judge approved these statements. Now, the reason I'm wording it that way, John, maybe you can shed some light on this. The document itself was either written by the judge or it was written by someone in the court and the judge stamped it. So when we say the court stamped documents, these were stamped. And that stamp basically signifies that the judge is signing off that these are his understandings and these are his words. That's what that stamp means. Is that right?
Yeah. So the Supreme Court's finding is going to be their own verbiage. I've never heard of attorneys like ghostwriting an order effectively. So, and I don't know that that's what took place in this. Occasionally, what will take place in litigation is the judge will basically tell the parties his opinion and say, now I want the parties to collectively work on an order and have me sign off on that. That occasionally happens. I'm not sure if that happened in this instance. We don't know exactly if the judge wrote all of this himself or if the parties basically collaborated to create an order and then the judge signed off on that.
I'm confident. Oh, go ahead.
I was going to say, considering the strong language on this, it would be my opinion that I think the judge wrote this himself. I don't think that the attorneys would do that. I as an attorney with my client, would not allow the same strong language that was used in this order to be released personally.
And I don't think that Sunder's attorneys would have written or drafted this either.
Or agreed to it. So even when you're the losing party, or when you don't win on a motion or something like that, and you have to agree to like some kind of joint order or something like that, you still are crafting language between yourself and the other side, and language that's really inflammatory, unless that's the exact language that the court used. It's rare that at least I, as an attorney, would ever allow that in. So my opinion would be, I think that this is directly the court's language. I don't think that this is the parties. But we did note that it could have been, and the court basically stamped off on that, just in case that's how the court came to these opinions.
But the court did read this and they did stamp off on it.
Either way, this is the judge's opinions. Once a court signs off and stamps off and a judge signs it, it becomes the court's opinions. So whether the parties jointly created this opinion or whether the judge drafted this unilaterally himself, either way, it's the court's opinion.
So it is the court's and or judge's opinion that Britton's email now drips with irony, as Sunder is currently attempting to enforce the restrictive covenants against Jackson that could last even longer than the 2 years that Max did not like, and Snell and Wilmer agreed was too long.
Yeah.
So here we go. I just put that back on there again because that was interesting to me. But Sunder has tried to argue that Britton was differently situated because he was an independent contractor who only received restricted stock units as part of his compensation, while Jackson was head of sales and a part of owner of Sunder. There is actually very little, so this is the court's opinion again, there is actually very little difference between them. Jackson was an independent contractor, and both Britton and Jackson held vice president titles. As discussed below, although Nielsen and Britton formed Sunder with Jackson and the co-founders, they worked with Snell and Wilmer to convert the other co-founders' interests into nothing more than a form of incentive compensation.
Mm-hmm. Yeah, so we're going to learn here in a minute as we go over it that the initial understanding of what all of these co-founders were changed as amendments to the operating agreement and an actual formal operating agreement came out. What they were changed.
And what is written in this agreement is what makes me sick to my stomach. Anyone that's been on these Facebook groups or anything I do not like bullies. I do not like when people mislead, and I certainly don't like when it happens to me. Jon has been part of some of the businesses and interactions I've had in contracts, and the misleading is absolutely repulsive and disgusting when it has happened to me. It makes me frustrated. It makes me angry. My family has suffered from it. My son, who has special needs, has suffered from it. I have suffered from it. My son's mom has suffered from it. I do not like this type of behavior. So here we go. In the fall of 2019, Nelson and Britton engaged in Snell and Wilmer to draft the LLC agreement for those co-founders. The other co-founders were not involved in the process. That's okay. When I went through this, my forte was recruiting and knocking doors and training and doing all the things that managers and regionals do. I have to trust that my partners, who they understood them to be, can go and handle the things that they are good at. I'm good at revenue generation. They're good at running a business. Go ahead, Jon.
So Jake, let me say this, right? So the initial understanding was when Sunder was filed, they just relied upon standard Delaware, like a standard Delaware operating agreement. When you file, there's just kind of standard terms until a formal operating agreement is submitted with the state, created and submitted. And so I think what the court is saying here is not just that like maybe one specific person formed the operating agreement, like a delegation of that responsibility, but they're actually talking about the involvement, and all of the co-founders should have been involved in that process, even if it's just in a matter of understanding their rights, which is I think what the court is saying here, that they weren't involved in the process of even understanding their rights as they were being drafted in the operating agreement. And that's very important because they needed to understand what was taking place. It was somewhat turning into like a bait and switch based on their understanding of what their role and their interest stake was in Sunder.
But that bait and switch it's not something that's just fabricated out of thin air. You're going to see why that statement was said. When the draft was ready, Nelson and Britton went to Snell and Wilmer's office, and attorneys from the firm walked them through the agreement. The other co-founders were not invited to that meeting, and no one explained the agreement to them. What the heck, man?
Yeah, so these guys are now getting the explanation from the attorneys, but the other co-founders aren't getting the same luxury and privilege of having it explained to them, which really is significant.
It is. Nielsen testified that he could not have understood the 2019 LLC agreement without the attorneys explaining it to him, and he invoked privilege in response to the questions about the 2019 LLC agreement on the grounds that his understanding came entirely from counsel. he didn't understand the agreement himself. He had to go and ask Snell and Wilmer what it actually all meant. Yet the other co-founders couldn't participate in it. The 2019 LLC agreement dramatically changed the ownership structure of Sunder and radically altered the internal governance. Nelson and Britton had their rights supercharged. This is a screenshot from the actual court documents. Nelson and Britton had their rights supercharged. The other co-founders had their rights emasculated.
Yeah. So Jake, talking about strong verbiage, stating that the other co-founders had their rights emasculated, it's very rare that a court will use like verbiage that has some kind of like, I'll say sexual context, but as far as like a male versus female type context, and using the word emasculated, I mean, the actual definition of it is deprived of his male role or identity or made weaker or less effective. I mean, it's a very strong word to use in that. But I think that's appropriate, right? Because of what they had before this operating agreement was established versus what it turned into after, like unbeknownst to the other parties. I mean, it was a drastic change. And so I think that's what the court is really recognizing here, that Nielsen and Britton had their rights dramatically increased. And then the other co-founders, were chopped at the knees, for a lack of better terms.
It makes me wonder, like I'm happy I don't even get a C, but it makes me wonder what was submitted in those depositions and in those texts and in those emails. Like, it makes me wonder, because to write that, it, like, obviously the person that understands this case better enough to put this on here was tremendously affected by what they witnessed in order to write this.
Well, and we assume that, right? Based upon the language that the court's using it. They could have just simply said the other co-founders had their rights removed, and instead they used the word emasculated. Now, as a trial attorney myself, I have drafted many a pleading and a petition, and you as a lawyer are constantly thinking of the verbiage that you want to use. And sometimes you use language that just gets it across, saying removed. But to use the words emasculated, I think the court wanted to make a point, just that the rights that the individuals had before was chopped, and I think that's the point that the court is making in using such strong language. They really want to make it a point to say that.
I asked ChatGPT. I'm not a lawyer, so I asked ChatGPT to
also
summarize.
No one should ever rely on ChatGPT. Just for the record, it does a great job in summarizing, not perfect, but no one should ever rely on ChatGPT for anything legal.
That's fair, but it's all written over here on the document, so you guys will have access to it.
Exactly.
But I asked ChatGPT to summarize it in an easy way, and this is what they came up with. Nielsen and Britton had full control over Sunder, managing it through a board consisting only of them and their appointees. They alone could approve compensation agreements and created two types of agreements of ownership, common unit. We can go on. It was a lot for me. So I asked ChatGPT to make it even more simple. And I'll read this to you. Nelson and Britton were in charge of Sunder and made all of the big decisions. I asked ChatGPT to write it like I was a little kid. They gave themselves special ownership with full control, while the other co-founders got a different kind that had no power. The others' shares took time to fully belong to them. But if they left, they lost the ones not yet earned. And sometimes Sunder could take them back for free. Only Nielsen and Britton could decide on deals, sell shares, or get extra legal protection. They could also make others go along with big decisions and stop them from selling their shares without permission. Everyone who signed the agreement had a chance to ask a lawyer about it first. Now, that last sentence I want to go over because we're about to get into New Year's, and New Year's is an important topic. Just in this document, we refer to it as the New Year's night. We're going to get into that, and the question is, did they really leave it up to that? Did they really have a chance to read it? I mean, we'll go over that, and that's speculation. That's up for the courts to decide, but you guys determine yourself. For me, like I mentioned earlier, if I was one of the co-founders and I was operated with in this way, I would have strong feelings about it.
Yeah, and again, your points here are heavily summarized down, right? And it doesn't necessarily explain the full context. Those that are watching this can read the full context of what took place in the actual operating agreement and read it. I think that the points do a good job in kind of boiling down to very simplistic terms, kind of what shifted and changed. The easiest way to understand it is, each of these people thought of themselves as co-founders and effectively partners, even
In
if they had a
depositions, in the interviews, and everything, they use that terminology. We're co-founders, we're partners. Nothing has changed. Go ahead, John.
Yeah, and they, even though the ownership stakes were different, right? With Nielsen and Britton owning 60%, the rest of the parties still believed they had the same rights and protections and things. One clear thing that stuck out to me when I read that was the indemnification clause is only applied to Nielsen and Britton. What that meant is that arguably the company Sunder would only have to indemnify or protect Nielsen and Britton, that they weren't extending that same level of protection out to the rest of the other co-founders. And
Mhm.
that would be a big strip of what people thought as if you're going into this agreement, we're helping build this company, thinking that you had that same level of protection. I think it was a massive change in addition to all the other changes that were made.
But wait, there's more. Okay. Under the 2019 LLC agreement, the co-founders, other than Nielsen and Britton, who they call now the minority members, went from being co-owners of a single class of equity to powerless holders of nothing more than a form of incentive compensation that a business might offer to a line employee. So,
Yeah.
although ChatGPT did summarize it for a child, like I asked it to, this is very clear. This is a screenshot from the court saying the identical thing.
Yeah, I mean they were stripped of their rights effectively, and that's why I think it's so important the timing of when this was given to them, this New Year's Eve night, which we're going to talk about.
Nelson and Britton sprung the 2019 LLC agreement on the minority members. Sprung it. That's the court's terminology. They sprung it on the minority members on New Year's Eve. When Nelson sent minority members an email that attached a PDF, and later on they say that the fact that it's a PDF is important, meaning that's just a more finalized version of it. Because typically, what you do if you want someone to go through and understand something and edit it, which in the legal world they call redline it, they don't send it in the PDF format. Addressing the minority members as partners, he wrote. So here is what was written in that email. Max Britton, so this is Eric writing it, and I have executed our portion of the Sunder operating agreement today, and a copy for your review is attached. I will be sending each of you a couple of documents via DocuSign momentarily. The first one contains your grant of shares, and the second one is a joinder agreement that will formally add each of you to the operating agreement. Operating agreement, for those that don't know, is just the contract that you sign from owner to owner to owner to understand what your role is within the company or what your ownership is of the company. The first one contains your grant of shares, and the second one is a joinder agreement that will formally add each of you to the operating agreement. If you are married, your spouse will also be sent a spousal consent form. Please let Max or me know if you have any questions. Lastly, the attorneys, and the document refers to the attorneys, because he's alluding to the idea, at least this court document says he's alluding to the idea that the attorneys also represent the co-founders, but we learned earlier that the attorneys no longer represent the co-founders. They represent Eric and Max. But Eric is letting the people reading it, the other co-founders, read it as if these were their attorneys too, having their interest in best of mind. So, lastly, the attorneys highly recommend completing these documents by the end of tonight. It is New Year's Eve, but we don't expect any of you to sign something if you are uncomfortable with it or you need more time. You'll find out later in these documents that the courts did not necessarily like that. And in fact, in previous cases, when things are worded in that way on a night like New Year's Eve, it's like a hidden veil of honesty that's manipulating and leading people astray. Oh, to feel like, oh, we're protected, we don't need to.
Well, I think the fact that they, they're not saying, hey, we're requesting you sign these tonight. They're saying, well, hey, the attorneys recommended that you complete these by the end of tonight. So
Not
kind of,
even the attorneys representing them in this case.
well, and there's some confusion there, right? Or at least there could have been confusion where these attorneys arguably represented them in the prior legacy matter. It wouldn't be unusual for, Jackson or the others to think, oh, well, okay, these are the attorneys that I worked with before. I can trust them. They're my attorneys. If they're recommending I sign this tonight, then I could trust that. And I think that distinction of these attorneys are now focused on working for Sunder, not them individually, that becomes an issue. And
Mhm.
also, when they're referencing that the attorneys are recommending they complete these documents by the end of the night, I think that there's that immediate effect of, well, I trust my attorney. If he recommends I sign them, what's the worst that could happen? I trust him. It must be okay. And then they throw out this little clause, but we don't expect any of you to sign something if you're uncomfortable with it, or if you need more clarification from the attorneys. So one, if you're uncomfortable with it, but they don't say uncomfortable with what? The fact that they're giving up basically any real rights, that they're getting now these incentive units. Um, uh, and also the fact that if you need more clarification from the attorneys, right? Referencing that higher authority again, it'd be easy to understand. Oh, okay, well, I guess I could talk to the attorneys because maybe they represent me, or maybe they, will provide me unbiased legal advice or opinions. So I think in my opinion, I think that's a little deceptive. Um, they're arguing that, hey, we didn't force them to sign this. They could have taken the time, but now the attorneys are telling them get it done by the end of the night. Now they're saying, well, only if you're uncomfortable with it, then you go to the same people that are recommending you sign tonight. So yeah, I think that's a little deceptive.
But we don't expect you to sign something if you are uncomfortable with it or if you need more clarification from the attorneys on something. Please let me know if you have any questions. Happy New Year. Happy New Year, co-founders.
Lady Justice would not do that. So
You know her better than I do.
I have her tattooed on my leg.
Oh, you do?
I do. Yeah.
The New Year's email did not reveal that the 2019 LLC agreement took away key rights from the minority members. So now they're no longer partners; they're minority members, and it didn't illustrate that.
Mm-hmm.
Nielsen mentioned your grant of shares, but did not clarify that minority members were only receiving incentive units, not common units like him and Britain. The email did not explain that the two types of shares had very different rights, with incentive units being just a form of compensation. I mean, I get it. I get it, but why? I just, if Eric and Max are watching this, why? 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 Why didn't you tell them that these things were changing and that it was no longer the same equal equity? I mean, why? Was there some agreement that happened outside of deposition and text messages and emails? Was it an epiphany from God? Did someone say it in the wind? Why are you doing this to people? It did
Well,
not warn. Go ahead.
and it's unclear too what level of attorney involvement took place. And I'm always very careful to bag
But
on
he
my
went,
own.
it says in here that he went to Snell and Wilmer and said, I don't understand these myself. Please describe them.
Yeah, and so that's something that we don't know. What took place behind closed doors? Did the attorneys flat out tell them, "Hey, look, this is what you're doing now to these other shares"? Did they just present it like this and they signed off? I mean, either way, this should have been a question that was asked, and more importantly, discussed to others. Like you said, it's a bait. At least to me, it looks like a bait and switch as far as what their understanding was and what eventually came to be in the formal operating agreement. And most importantly, it was different from the technical Delaware operating agreement that was in existence. And that's the issue for the court, at least initially, is now they're doing something different than what was initially agreed upon in the initial formation of the corporation. And you can't amend things unilaterally. You can't just conceal things unilaterally. You have to disclose those. And that's the court's concern, is that these things were not being disclosed to the other members.
You guys, this is a tip of the iceberg. There's more coming, and not even surrounding this. There's other stuff that occurred, but I want everyone on here to know I do my research. I am the one that asked it, like, hey, can I bring you into this? Can I bring you into this and like help me curb this? Like, I want to deliver to you quality. And I think any of you know my reputation. I don't take sides. I am literally reading this and I'm expressing my feelings that have happened from the past. I did, in light of that, I did call Eric and Max before I started any of this, because in the past they told me, we want you to call and ask us any questions that we can clarify. When I called them and started talking about this and inquiring about it, they did something that I actually would say is commendable. It's what you hear in the movies. John, tell me if this is the smartest thing you do. We're told to shut up in the Miranda rights. Also, he said, this is an ongoing investigation, which I don't know. I don't know if that is an ongoing investigation. I think the investigation's done, but he said this is an ongoing investigation, and it's in our. I'm paraphrasing. This isn't a quote, and it's in our best interest not to disclose any further information than what's been provided, and they don't want to. They didn't want to comment at this time. Now that's probably the admirable and smart thing to do. Is that right, John?
Yeah, so there is some points on this litigation that we're not clear with, right? So the litigation itself, when we obtained the documents, the court informed us that the matter is still being treated confidentially, right? So as an attorney, for example, if litigation is sealed, for example, or if there's just parts that the court doesn't want disclosed, such as people's social security numbers or maybe specific business strategies that are proprietary, things like that. The court might choose to make sure that those portions are kept confidential by the parties. And so as an attorney, I might advise my client, hey, let's not discuss ongoing litigation, which is probably what he said instead of investigation, with that it's ongoing litigation.
Okay.
I've been advised by my attorney not to discuss it. I would advise my clients on the same thing. It's ongoing litigation. I would advise my client not to discuss it, with some exceptions to that. So much of this is already documented. It's already public. And so them providing an opinion on what's public would have been totally reasonable to do. And I would advise you the same thing. For example, if they're saying here, well, wait a second, I had this offhanded comment with them and I explained these shares or something. Well, that's not in the document. And that would be something that you, Jake, that they could have discussed with you that they chose not to.
Well, it's
Now,
not in discovery either, because if it was, it would be in here.
well, maybe, right?
Okay.
Arguably, it should be, and the judge would have relied on that. But the discovery for this process is limited, and they should know that the discovery is focused on these issues. Now, the court did a very broad sweep, and that's part of the reason why the Supreme Court took notice and they had some opinions on that. But the Chancery Court did a very broad sweep of all of the issues in this case and released a very well reasoned and factually based finding. And so I think that based upon what is in the public, it would have been fair I would have advised my client, it would have been fair for them to comment on some of these things and provide a response, especially where this is documented. This is out from the court and the Supreme Court's finding.
Yeah, sure. And, just these things are in here. I don't think that there's going to be anything that is sealed or that we can't see that says, hey, they split apart from Legacy and they're suing them, or these were the co-founders and they no longer have the same shares. I don't think those things are going to change.
It
Right?
wouldn't change. It wouldn't change the court's opinion on this injunction. It wouldn't change the court's opinion even if there was something else filed, because this is their opinion, and the court would have access to
Of the
all
things that
facts.
were filed. Yeah.
Correct. Yeah, correct. Of course, like you said, like there still are some remaining issues to be tied up, and the discovery rules for that might be different than the discovery rules for this injunction. But nevertheless, for this injunction, the court has laid out a lot of the facts and documents that it's relied upon, and so it's not like there's concealed documents in relationship to these findings.
Thank you. The email also failed to mention that the law firm representing them in another case was only representing Sunder for the new agreement.
Yeah,
So,
and
yeah,
that's
go ahead.
confusing to me, Jake. That's in my opinion, it's highly confusing. Now, what probably happened was Sunder probably hired their attorney, and again, I'm speculating, so but Sunder probably, hired the attorneys to defend the co-founders in the initial action with legacy. That's not uncommon. Businesses do that a lot. But it has to be very clear as an attorney to these individuals that that even though you are the client, I've been hired by the business to do this. Now, the client remains those co-founders, regardless of who is paying that bill. But now when the law firm switches gears and is just representing the interests of the business, that becomes a problem, because attorneys have to be very clear with their clients of where clients know that they are the client or they're not the client. And it probably could have been eliminated with a conflict waiver or some additional documentation. I don't know if that was ever done or discussed, but it does appear that the court recognized the fact that the individuals relied upon this trust relationship with these attorneys, and there's some conflict there. So I thought it was very
Well, I
important.
would
that the
too
court pointed that out.
if it was insinuated that they were my attorneys also. I would also
Oh,
have
yeah.
trust in my attorneys, right? Like, they didn't know at that point that those attorneys were, I don't know if I'm allowed to say this, but conspiring against them.
Well,
And not
I wouldn't say conspiring against them. Let's be very clear.
conspiring against. No, I'm just kidding.
No, that's, and again, talking about strong language, I would say that's very strong language. We don't know that, right? Often as attorneys, we get asked to draft documents. They'll say,
Well,
hey,
what word
this is
would
what I
you
want to do.
utilize by stripping? I believe the terminology is in here that they stripped their equity away and gave them a different type of equity that was powerless.
I would say this: it depends upon who instructed them to draft the operating agreement. And that is something that I didn't find in the documents. Was this entirely done by the attorneys, or were they instructed to draft the document in this way? We do know that Nielsen Britton met with the attorneys, went over the operating agreement with them, and all of that. So my opinion would be that there was input from them, and maybe they directed them to do this. I don't know, but somebody drafted that operating agreement that stripped these rights. And so normally attorneys will take the direction from their client. They say, tell me what you want to do. What are everybody's roles? And they draft the document for that. It's usually not aggressive. Lawyers are bound by bar rules. So it's very, very extremely rare that a lawyer would take that kind of conspiratorial approach. But do I think that they should have disclosed some of these things to the other individuals since they previously represented them? Yeah. And I can't say that it wasn't. But I do know that that's not something that I read in the documents, at least not something that I remember seeing, that they disclosed the fact they were only
They
representing
did not
Sunder's
in
interests.
the
So,
document.
so that's an issue. That's a huge issue.
Instead, the New Year's Eve email implied exactly the opposite. Namely, the signing of the 2019 agreement was something that the minority members could get out of the way quickly before continuing with their celebrations. Nielsen observed that he and Britton had already executed the as circulated copy, and although it might seem like a small thing, he circulated the document as a PDF as if it were in final form. He urged the minority members to sign that night and told them that the attorneys, they put that SIC there because they want to reference that the attorneys did not necessarily represent the others. Highly recommend completing these documents by the end of tonight. That's in quotes. Note the use of the definite article. He did not say Sunder's attorneys, who were really acting as Nelson and Britton's attorneys. He said the attorneys.
Yeah,
that's important. That's big.
So again, people have to understand that there already was an agreement in place, right? When Sunder was formed and filed in Delaware, there already was an agreement in place. So what is being circulated now in New Year's is basically a new formalized operating agreement, or arguably an amendment to the original agreement, right? Now they're trying to amend the terms that were previously agreed upon to something new. So the fact that there is no, we call it in the law, we call it a meeting of the minds. For there to be an actual contractual agreement, there should be a meeting of the minds to be able to have that level of assent to the contract. And so here, where they didn't send it in a Word format so they could redline it, they sent a formalized PDF. Now that's showing the court, this is a unilateral decision. This is what we're giving you. You can take it or leave it. So there's no ability to negotiate that, even if it was a point. Also, the timing, the court really emphasized that timing, that New Year's Eve. I believe Jackson signed it, if I'm not mistaken. It was about like within an hour, I think, of when he received it. So the timing there, he didn't have enough time to review it, process it. They're kind of relying on these things, relying on the attorneys, and again, noting that it wasn't clear that the attorneys were Sunder's attorneys or those effectively acting as Nielsen and Britton's attorneys. They just used the term the attorneys. And so that's misleading as well.
Yeah, Nielsen used the term the attorneys without indicating that they're his attorneys, alluding to the idea that these attorneys represented them as well, which they clearly did not.
But they had previously. So it would have been very easy to think, oh, yeah, our attorneys. I have had the same issue where I had to be very clear. Hey, I'm not representing you, just so you know. Like, I represent the business, and that needs to be clear. And so that was never expressly done. And I think that really misled the parties.
Not only that, but Nielsen circulated the signature pages by DocuSign. That meant that the minority members did not have to scroll through the 2019 LLC agreement to reach the end and sign it. They only had to look at the one-page joinder agreement. Now,
yeah,
everyone knows, we've already heard from the time we were kids to read the documents, read your contracts before we sign them. I'm not saying that the idiocracy, that's a strong word. I might have pulled that somewhere from this court document, maybe not. I'm just going to say that's not my word. But not reading this certainly led to ramifications that maybe the outcome is not what they wanted.
Well, and Jake, something that we do, I know, for example, in all of my contracts, when I send them via DocuSign, and an attorney should do this, we make sure that people initial every page. And this is a great practice pointer for every company, every business owner, everyone that's watching this. It's so simple to just add a little button at the bottom of every page, just making sure that they've initialed every page. What the court's saying here is that you clicked start on the DocuSign and then went all the way down to the bottom and they click sign. And so there's no way to know that they actually like read it and understood it. At least Sunder could have had another argument to say, well, look, they initialed every page, meaning that arguably they read it, or having a little initial box by key points. Like if they had a little initial box next to that 8% change, turning into the incentive value or incentive compensation instead of what they originally understood that value to be, a partnership. Then they could have then they could have alleged, look, they initialed it, like they clearly saw it, they understood it. They could have raised that argument, but because it wasn't initialed and they didn't have to scroll through the agreement, they just had to click the button and sign all the way down. At least that's what we interpret from this court opinion here. That to me says, they didn't even read the contract because they didn't know, which is not good, but is not uncommon.
What makes me sad is that I don't know, these organizations. I worked at a big bright orange one. They create the strongest Kool-Aid. I mean,
are you talking about Home Depot? By the way, I see that.
They create the strongest Kool-Aid you could ever imagine for culture and believing that you're well taken care of and this is the place to be. And there are some people that are going to listen to this and they're still going to say, "Oh, I love this company still. That's okay. The leadership here is honest and integral." But I mean, if you were to look at the facts, if you were to strip the Kool-Aid away and look at the black and white writing that's on these things, like how can you say that still?
Well, I think that there's a lot of issues. I would say, just like all things in life, no one is perfect. But the reality is people need to understand that sometimes those imperfect decisions have massive consequences on other people's lives. One point that we're going to talk about in a minute is one of the restrictive covenants in here would have even impacted Jackson's daughter's medical condition had it been enforced. That simple reality in how one simple clause can impact somebody's life and their family and their children, that's substantial. And so, yes, people can be imperfect, but they need to understand that those imperfections have real world consequences. And
or you can get emasculated.
Yeah, and I don't think that was fully considered here.
So the minority members, now minority members, were all high school graduates who had spent all or most of their careers in the door-to-door sales industry. They were not sophisticated in legal matters. They trusted Nielsen and Britton, their partners, quote unquote. They put partners in quotes, were representing their collective interests as fellow fiduciaries, nothing about the email put them on notice that their partners were acting self-interestedly, and that I'm going to go back to school so I can read those words better, and that the minority members needed to protect themselves. Nor is it reasonable to infer on this record that the minority members would have understood the traps in the document. They use the word traps in the document if they had read it. Nelson testified that his understanding of the document only came from his attorneys and that he had no other understanding of the agreement.
Mm-hmm. Yeah, and so that's the concern, right? Nielsen's saying I only understood through my attorneys, and so all the other partners, the court's saying, how would they have even understood it, even if they had fully read it? They have no legal background,
In
and
1 hour on New Year's Eve.
exactly, and also the fact that the court is saying, and also the fact that Nielsen and Britton were considered their partners, that they had a fiduciary responsibility. That word fiduciary is a legal term, and it's broad, but it means that you owe a responsibility to other people for specific things, like good faith, fair dealing amongst your partners, and not some of these actions that have taken place, which the court did point out that it effectively was an egregious breach, is the terms that the court later uses, of their fiduciary responsibilities.
Yeah, and there's another part of this where people are saying like, hey, these documents, they were drafted in 2023. Why is it relevant now? You'll see on another document that came from the Supreme Court that went and reviewed all of this stuff. They determined just a couple months ago, it was December of 2024, a few months ago, that no, all of this is accurate. Like we are still denying these things. We're still denying the injunction. So it is very relevant today. Even after radically altering their relationship with the minority members, this is a screenshot, Nelson and Britton continued to refer to them as quote unquote partners. Testimony from Jackson and other minority members in the legacy action shows that they continued to believe that they held equity with the same rights as Nelson and Britton and had no idea that their rights had been altered. Jackson testified to his understanding that the LLC agreement did not contain any restrictions on his ability to compete with Sunder or solicit its customers or employees.
Yeah. So Jake, that's just for the record, that's why I said it does seem a little bit like a bait and switch, because even later on in 2022, they're still discussing themselves as though they're equity members with the same rights as Nielsen and Britton. They didn't know. Even years later, they didn't know that they weren't being that they didn't have the same legal rights as those two.
Yeah, go ahead.
So that's a problem. Yeah, that's the issue. Clearly, they didn't know.
And all of you should wait till the end of this podcast. I understand it's going a little bit longer, but we wanted to take the time for you to understand what's happening and what's actually literally written here. Excuse all of my personal feelings on the matter, but having been burned in this, not just solar industry, but in the door-to-door industry for nearly 20 years, I have feelings about it. So there's more to come. This isn't even the most egregious stuff. You'll see more as we go, but continue to listen to the end. From 2019 until earlier 2023, Sunder thrived while utilizing freedom support and services such as payroll commissions, calculations, and marketing. And I remember, talking with some of the people that worked at Sunder when Sunder split apart from not just Vivint, not just Legacy, but also Freedom. Good Lord. When they split apart from Freedom, Freedom was doing the payroll. Freedom was also doing the marketing, and Freedom was actually helping them grow as a business. And when they split apart, Freedom decided not to pay Sunder, but they did pay all of the sales reps because they were already on payroll. The sales reps didn't break the agreement. The owners of Sunder did. And so Freedom kept paying everyone in full. They just withheld payment from Sunder. Under Sunder, Jackson received direct authority over many markets, including Texas, Florida, Arkansas, California, and South Carolina. He received the title of vice president with nearly half of Sunder's sales force reporting to him directly or indirectly. This is where I would love to be Jackson. Yeah. Jackson became the highest paid sales leader at Sunder, earning $4.8 million over 4 years and another $1.2 million in incentive units. Jackson, There's a car I would love if you don't mind co-signing. Let's talk about this later. Uh, in incentive units, but Jackson nevertheless remained an independent contractor with Sunder. His officer title was just that, a title.
Well, yeah, he didn't know. He wasn't aware, presumably, that he was only a title.
I mean, in deposition and in all of the court documents, he wasn't aware. In 2021 and in 22, Nelson and Britton made business decisions that created problems for Sunder. This is where it starts to get super interesting, where people paint freedom as this bad giant monster, and it's like, who's the real monster? Let's decide here. It's not up for us to decide. This is why we're presenting this to you. These decisions strained Sunder's relationship with Freedom and its sales force. Obviously, Freedom, seeing Sunder as an essential partner, proposed an equity swap in 2021 to strengthen their connection. Freedom said, "Hey, Sunder, we understand that you're independent and separate." They're still under exclusivity, mind you. During all of this process, they're still under exclusivity. But they said, "Hey, we want to strengthen our bond, and so let's talk about us purchasing equity or an equity swap." Initially open to the idea, Nielsen and Britton later rejected the equity swap in 22, preferring to see private equity investment instead. Now, just to let you know, Freedom was proposing, because they have Vital, Boundless, and now Solar Pros. At the time they didn't. Sunder was set to be Solar Pros, but now Solar Pros is Solar Pros. They're saying, "Hey, we want to strengthen this relationship with you, and we want to bring you in as partners. So we'll give you part of our equity and you give us part of yours." If Sunder had done that at the time, then they would have had equity in the umbrella. I'm calling it an umbrella. I don't know if that's a true term, but they would have had equity in Freedom, who also held Boundless and Vital, to some capacity. So initially open to the idea, that Nelson and Britton later rejected the equity swap in 22, preferring to seek private equity investments instead. To attract investors, here's where it gets naughty. To attract investors, they tried to boost Sunder's profit margins, including exploring financing outside of Freedom's network. Not too big of a deal. From what I understand, they really hurt Freedom here, because Freedom had exclusivity agreements with financiers, and Sunder was going out on their own and finding some financier deals themselves. But oh my goodness, stay tuned for what's coming next, because goodness, if you are a sales rep at Sunder, I highly encourage you to understand what's about to be talked about here. This move conflicted with Freedom's exclusive agreement and worsened tensions between the two companies. With the cost for installation. So here it is, guys. Here it is. To increase Sunder's margins, Nielsen and Britton caused Sunder to pad the installation costs, creating a higher artificial floor for the deal. When calculating sales commissions and sales leaders' overrides, Sunder used the higher artificial floor and pocketed the difference between the artificial floor and Freedom's costs. Are you kidding me?
Yeah, that's. I don't exactly have words for that statement in the legal document. It is. Well, I'm going to be very careful in how I discuss that, because I think that that statement alone could create other potential legal liabilities. But to state that for the court to state that they were padding installation costs, creating an artificial floor, and then they were using that artificial floor to pocket the difference. I don't really have words as a business practice. I just think that it's not good business practice, to put it in the most legal terms that I can think of. I think that it also is deceptive, in my opinion, is deceptive for those guys out, making the sales and putting in the effort. But that, of course, is my opinion on that.
More money for Sunder meant better financials to show a private equity investor, but it also meant less money for the sales commissions and overrides. As a practical matter, and this does bite them in the ass later, as a practical matter, the padded installation costs meant that Sunder was taking money from its sales force. That's a court quote. Sunder was taking money from its sales force.
Yeah. I have no words for that.
Sunder sales representatives eventually discovered that Sunder had secretly changed its calculations, and was taking a portion of their money. Not surprisingly, that news went over like a lead balloon and generated feelings of betrayal and distrust. No kidding.
Yeah, it's interesting
Gross.
that they use that went over like a lead balloon. Again, the courts start using descriptive language in this, and I find it interesting where they decide to use it.
Yeah, it's like a creative writing piece for the court. Like they were so moved by this passionately that instead of writing some neutral black and white text, they decided to go creative writing style.
Yeah.
All right. By the early 2023, Sunder's sales force, especially its leaders, were uncertain about staying with Sunder or moving to another Freedom dealer. Solar Pros, a fast-growing dealer backed by Freedom, became an appealing alternative. Solar Pros offered better commissions and no artificial pricing floor, leading 63 Sunder sales professionals to switch in spring of 23. Jackson, a Sunder sales leader at the time, explored leaving and met with Freedom executives in May of 23. Jackson obviously, I'm not reading this. Jackson was obviously bothered when he found this out, and that distrust, like the court said, came to fruition. Jackson had a long-standing friendship with Chad Towner, Freedom executive, and frequently interacted with Freedom's leadership. After the meeting, Jackson requested copies of his agreement with Sunder, signaling that he was seriously considering leaving. Jackson tried to maintain the Sunder Freedom relationship and keep his sales team together, encouraging meetings between Sunder and Freedom, while persuading his leaders not to leave for Solar Pros. So Jackson, to me, it sounds to me like he was trying to play peacemaker. Hey, why don't you guys communicate with each other? And he's telling his team, don't leave yet. Like, let's try and instigate this mutual benefit between the two organizations. Despite his efforts, he stayed in contact with Towner throughout June. You know what? For me, the solar industry, the home securities, door-to-door industry, shame on all of us, all of you, and me included. Like, now that I've grown older, like it's disgusting to me to think that like I have a friend that I've known. I'll just bring up Ben Mack. I have a friend that I've known since 2001, I believe it was. When we became besties, and we did wear different shirts. We worked for different companies. The idea that we wouldn't be able to communicate with each other or that was bad, our friendship went way beyond the brand on our shirt. I do feel and find value in communicating with my friends despite the company that they work at. So if anyone's looking down on Jackson for talking with Towner, they were friends long before either of them put a brand on their shirt. Like, you would talk to your best friend too, right? By this time, Jackson directly managed 7 sales leaders, many of them who later left Sunder for Solar Pros between September 11th and 19th of 23. During the same period, Nelson and Britton were keeping their options open. In June and July of 23, they began having meetings with other solar installers. This is a breach. That's not saying it on here, but this is a breach of their exclusivity agreement. In August of 23, they hired counsel to evaluate Sunder's rights under the dealer agreement. Grant was deeply offended by Nielsen and Britton's secret implementation of the artificial pricing floor, and he no longer trusted Nielsen.
And Jake, just to be clear, I mean, we don't obviously know all the terms of the exclusivity agreement, but like arguably an exclusivity agreement usually means exclusive. So we don't know if they were allowed to meet with other people or not. But it appears like they probably shouldn't have. For the court to recognize it, it's interesting.
Well, I mean, just by the definition of exclusivity, it would infer the idea that you would be exclusive. But you're right. We don't know the terms, but they should have called it something else. All right. In August of 23, Grant had a direct but professional conversation with Nielsen and Britton and Jackson, expressing his lack of trust in Nielsen. And you guys, I'm going to kind of breeze through these ones because it's not the meatiest of meaty stuff. But it is interesting to see that, the artificial pricing floor did end up biting him in the backside. Granch was, quick to advocate for that. Like, hey, I didn't like that. I lost trust in you. And as we saw, Jackson was too. When Nielsen reacted aggressively, Jackson calmed the situation, and Nielsen stated that Sunder's main goal was to extend its partnership with Freedom. So that's kind of cool. Nielsen admitted that failing to secure a deal with Freedom could lead to losing sales personnel, and Granch made it clear he would leave Sunder if that happened. Strong ultimatum there. At the end of August, Chad Towner and Brett Bushy decided hiring Jackson for Solar Pros and developed a plan for Freedom to pay Sunder to release Jackson from its contractual obligations. Jackson communicated with Freedom's legal team and shared the 21 operating agreement so they could assess his restrictions. That's the operating agreement that Sunder made it, or sorry, that Britton and Max made it. That's Max Britton and Eric Nelson made it. So it stripped their powers away and made him a minority member. So in early September, during the late night conversation, Jax told Granch that if he weren't bound by a non-compete, he would have left months ago, which convinced Granch to take his team to Solar Pros. And then we have this Las Vegas meeting. And you can see the court labeled it the Las Vegas meeting. With Jackson's support, Freedom arranged a meeting between senior management teams and Freedom's headquarters in Las Vegas, scheduled for September 14th of 23. On September 11th, so just before this meeting, Granch signed an independent contractor agreement with Solar Pros, followed by his two regional managers, Jason Tisdale and Josh Simmons, on September 12th. Granch informed Towner that his team was ready to resign from Sunder and join Solar Pros, but Chad Towner advised them to wait until after the meeting to avoid its cancellation. Expecting to leave Solar Pros, Granch's group began holding off on deals so they could process them through Solar Pros instead of Sunder. The September 14th meeting took place with Nelson and Britton from Sunder and Towner Bushy and Freedom's general counsel from Freedom. Freedom offered $10 million for Sunder's agreement to release Jackson from the covenants and facilitate the transfer of his team to pros. I'm just going to pause here for a second. And I know we're kind of breezing through this stuff, and kind of like the spicy stuff is kind of going down a little bit. But there is some spicy stuff coming up here in a little bit later. And I would encourage all of you to understand these documents the best you can, because this is how we operate in an industry. These are the clauses and the terms that we put in our own agreements. This is how we have been protecting our businesses. So understanding these things is just going to strengthen your agreements and your relationships with those that you work with. Freedom proposed paying 25% of the $10 million up front and $1 million per month. And they go through and talk about like the different terms of the agreements and how they wanted to negotiate. It ended up being that Sunder said, hey, you know what? We don't like those terms. We want these ones. Freedom said we weren't comfortable with that. And it goes on. Granch texted his team proudly, claiming that they were the catalyst for the peaceful transition, helping Sunder and Freedom reach an agreement for Jackson and his group to move to Solar Pros. Jackson's recruitment efforts. John's about to bring some documents up here soon. Jackson's recruitment efforts. After hearing the news, Jackson created and shared a list of Sunder's personnel with 3 senior managers to identify potential recruits for Solar Pros. Key Sunder employees, including Granch, Tisdale, and Simmons, resigned by September of 16, followed by Parker and Wilson's teams within the days. Jackson engaged in ongoing talks with Towner and Bushy about transitioning his team to Solar Pros. Jackson made calls and traveled to meet with Sunder sales leaders, speaking with at least 37 representatives about joining Solar Pros. On September 21st, Jackson informed his team that he had secured commitments from 3 Sunder representatives after hours meetings. Defendants argue that Jackson was merely identifying who from his group would join him, while Sunder claims he was actively soliciting employees in violation of the covenants. I don't know, John. What do you think about that? To me, that's semantics, and I would tend to probably side with Sunder on that.
Yeah, I mean, it somewhat depends. You can get into semantics, and arguably it depends on the side that's throwing out, the way that they frame their argument best. To me, it doesn't seem like Jackson is actively recruiting. It seems like he's kind of looking at his team and, and taking stock. It sounds like maybe in his mind, he thought that, yeah, there was this deal anyways, and everybody's good to go. And it doesn't seem malicious, at least in my opinions. But it would depend, really what Sunder's position was. Was he actively soliciting them? Was he, going to them, emailing them, texting them, asking these things? I'm not sure.
Well, and here it is. Even in you asked what Sunder's stance was, and here it is.
Mm-hmm.
Text message that they found in the depositions and all the reporting of those texts that were in different time zones. Text messages from Britain suggest Jackson initially tried to keep employees at Sunder. Contradicting claims that he was planning a transition.
Well, and I guess that's my point, is that I think it'd be hard to say that Jackson's actively soliciting when the text messages actually suggest he was trying to get them to stay. So I think, I would err on Jackson's side on this point.
Settlement agreement timelines. Freedom did not send Sunder a draft settlement agreement until September 18th. And there was no evidence of a board release of claims in the draft. On September 19th, Towner sent a spreadsheet identifying Sunder's sales representatives to key figures, allegedly to outline who would be covered by the separation offer. The employee list was compiled using Freedom's internal information, which was accessible due to the administrative support it provided to Sunder. Now, some of you... Go ahead, John.
That I was just going to say that's important, Jake, because one of the claims is tortious business interference. That was one of the claims that Sunder raised against Freedom, and Freedom's saying, "Wait a second, we're using the data that you gave us, so we're not tortiously gathering data out here, collecting it, from malicious sources. Like, this is the data that you gave us, and we're compiling it for use in discussions with you." And so, that's, I think, the court's point in providing that point is that, they gather the information from what Sunder was already giving them.
Sure. And it's only in the agreement between Sunder and Freedom what the liberties are in utilizing that data, which I don't believe it talks about in this document. Is it? Does it?
I don't recall that.
Okay. So, active recruitment efforts. Jackson worked for 5 days to recruit his team to Solar Pros, successfully transferring several key managers, including Grant, Wilson, Parker, and Roman. By September 20th, Solar Pros leadership confirmed that Jackson's team had been moved to their system, signaling a coordinated transition. Jackson formally signed an independent consulting agreement with Freedom Solar Pros on September 22nd, just hours before resigning from Sunder. Ironically, Jackson's new contract with Solar Pros restricted him from soliciting its personnel for 12 years after leaving, despite allegations that he poached employees from Sunder. Freedom Solar Pros agreed to indemnify Jackson against any legal claims from Sunder, including paying for any settlement or judgments. You guys, that includes what we're going over right now. Freedom has indemnified Jackson, meaning that they are going to cover the legal fees during this Sunder Freedom, what do you call it, John? Case? I'm going to call it a case.
Yeah, lawsuit.
Lawsuit. Although Jackson resigned on September 22nd, Freedom chose to wait until September 25th to publicly announce his new role at Solar Pros. Over the weekend, Jackson secured a top manager from Florida, spoke with a sales rep from Parker's region, and offered to recruit a Los Angeles team for Solar Pros. After Solar Pros announced Jackson's hiring on Instagram, Sunder leadership demanded a retraction, emphasizing that no formal separation agreement had been finalized. So it sounded like they were in some sort of agreement to this, but it wasn't necessarily formalized officially, right? Is that right, John?
Oh, sorry. Yes, I believe that's correct. Yeah.
Sunder informed Jackson that due to his resignation, he had forfeited his unvested incentive units, and that Sunder had the right to repurchase his vested units for $0. Now, remember, if Sunder decides not to purchase them, earlier it said that it could go perpetual.
Yeah, that's correct. So that's kind of the other issue that I don't think was adequately considered is that, yeah, they could repurchase them for $0, but if they didn't, what happens to those shares?
Sure. And what are the restrictions held on Jackson, right?
Correct.
Jackson continued traveling after resigning, flying to Alaska to meet with the sales team and later to Los Angeles for Solar Pro's sales kickoff event. On September 29th, Sunder terminated its dealer agreement with Freedom and filed both an arbitration case and lawsuit against Jackson, Freedom, Bushi, Towner, and Solar Pros. So the way that I'm understanding this, John, is they're breaking their exclusivity agreement here. They filed for it at least.
Yeah. So it sounds like, based on the court document, that they met with their attorneys, and now they want out. Now they want to get out of this exclusivity agreement, and they also want to make sure that they don't have loose ends with Jackson and Solar Pros and these other guys.
Even after the lawsuit was filed, Jackson continued efforts to recruit Sunder employees, including participating in a call wire where Towner offered $200,000 to a Sunder representative to join pros. You guys, I'm just going to breeze through these because I'm sorry. Here we go. Here's some of the spicy, saucy stuff John wanted to talk about.
Yeah.
Court issues a temporary restraining order, TRO, otherwise referred to as TRO. Hours after Jackson's recruitment document was shared, the court issued an ex parte TRO to preserve the status quo, which was later renewed on October 11th after a hearing. John, can you put that into terms that we understand, and can you tell me if I said the word parte correctly?
Yes. So parte doesn't mean it doesn't mean that anybody's partying. Basically, an ex parte meeting or filing or anything else, it means that you haven't given notice to the other side per se, or that you filed it directly with the court, right? So you've just gone unilaterally with the court to file this ex parte motion or whatever it is. This typically takes place with restraining orders. It's very common with restraining orders. You want to get that filed as quickly as possible, and the reason being is that you're trying to effectively stop the bleeding. If you're the company that's filing it, your attitude is, hey, we have to stop something. We got to get them to knock it off. And so they file this, and it is a temporary restriction. Courts will grant these, based on a showing of different factors. But the courts will, they do give a lot of consideration to companies when they say, hey, if you don't give this to us, we're going to suffer massive damages. We're going to be hurting and all these things. And so courts, take them kind of on their face, and trusting the attorneys that are filing and requesting these, believing that this is a reasonable need, that there's a reasonable basis for it. And will grant them, preventing them from doing business or from doing recruiting or whatever the temporary restraining order is specifically requesting.
Let's see. The case moved quickly with both sides engaging in expedited discovery, leading to preliminary injunction hearing on October 17th. And you guys, this is starting to get spicy again because, it's speculated, depending on the outcome of this, it could be the end of one of these two companies, likely the smaller one. So the court's decision to renew the temporary restraining order suggests that it saw ongoing concerns regarding Jackson's actions. At least at this stage of the case, however, this does not guarantee a final ruling in Sunder's favor. The defendant, John, interrupt me anytime you want. The defendant's attempt to dismiss the case in favor of arbitration under the dealer agreement raises questions about whether Sunder's claims should have been handled outside of the court system, potentially weakening Sunder's position. The court emphasizes that a preliminary injunction is an extraordinary remedy, which means Sunder must meet a high burden of proof to justify restricting Jackson's actions before a final trial.
Yeah, and ultimately, the court really has to consider this based upon what they're trying to get done, right? Sunder's wanting Jackson to stop. And so the court has to weigh out Sunder's needs for him to stop whatever his business actions are, by Jackson's needs to earn a living, to continue working and things like that. And even though, you're right that there is a high bar for injunctions, but the court will take into account realistically all of the facts that a business will put forward. If a business's lifeline is at risk, the court wants them to state why they believe it is, but they also don't want to unilaterally stop another business from acting in good faith. Which is why we'll talk about in a minute, but why the court determined that a bond was reasonable to issue in this matter.
I can't wait to talk about that bond. The court must weigh Sunder's need for protection against potential harm to Jackson and other defendants, making it unclear whether Sunder can prove that an injunction is the best course of action. The rapid timeline for discovery and the hearing on Sunder's motion for a preliminary injunction, a restraining order, indicate that the court considers the dispute time sensitive, but remains cautious about granting immediate relief. So Delaware courts generally require proof of 3 elements, and it goes on to describe what those 3 proofs are. John, we can breeze through these a little bit so that we can keep it okay. And then we'll just get to the point where we can talk about some of the, and none of this is favoring one side or the other. This is just describing how things are handled.
The legal process for it.
Yeah, thank you. The legal process is not anything where Sunder can say, oh, they didn't cover that, or Freedom could say, oh, they didn't cover that. This is just legal process that they're going over. Let's see here. Court's decision based on hardships, failure to meet the elements. Sunder asserts that Jackson has violated, we already know this, the competition restriction and personnel restriction covenants, and seeks preliminary injunction. Let's get out of here. Here we go. And remember, guys, all of these slides are included for you. So if you want to read through these legal processes, you can. Let's see. Influence of Jackson's departure, conflict law.
Yeah, so when people go back and read this too, read the conflict of law information. We don't need to talk about it here, but the court does go into detail of why they thought that Utah or Nevada or Texas might have been better for one side or the other, or why it might have been more advantageous for one side or the other to use different states' choice of law clauses or conflict of law clauses. So it's an interesting read, but of course, I recommend people go back and review it.
Utah's approach to restrictive covenants, Texas's approach to restrictive covenants is, and this is why Delaware says that some of these organizations could have been favored better in their respective states. So here comes some of the more meat stuff. Sunder has asked the court to apply Delaware law and not Texas law. Thus, even though Sunder would fare better under Texas law, the court will respect its choice. Jackson would have a stronger case for invalidity under Utah law, but because the covenants are invalid under Delaware law, the conflict is a false one, and the court can apply Delaware law. This decision, therefore, analyzes the covenants under Delaware law. Sunder has asked the court to apply Delaware law, not Texas law. Thus, even though Sunder would fare better under Texas law, the court will respect its choices. Jackson would have a stronger case for invalidity under Utah law, but because the covenants are invalid under Delaware law, the conflict is a false one, and the court can apply Delaware law.
Yeah, so this is just legalese. So, you go back and read it, and you can see, why one state might have been better for the other. But knowing that Delaware is now hearing this, they do provide their opinions on it.
The record establishes that Nelson and Britton breached the fiduciary duty of disclosure when making member approval for the 2019 agreement. They are recognizing that they breached fiduciary obligation. That's crazy.
Yeah. In fact, I think they later deem it an egregious breach of a fiduciary obligation.
Member duties, fraud allegations. Jackson argues the 2019 agreement was procured by fraud. That's a big claim. And I told you guys my feelings on it. That's let's see here. Application. When Nelson and Britton solicited the minority members, approval for the 2019 agreement, they owed a fiduciary duty to disclose fully and fairly all material information, as well as a duty to make misleading partial disclosures.
Not to make
Not to
misleading
make.
partial.
Thank you.
Exactly. You're
Not
welcome.
to make misleading partial disclosures, which it is believed in this document that they did do. Even assuming that the co-founders agreed that Nelson and Britton would be managing members rather than simply managers in the colloquial sense. Sorry, it's a little small writing. In the colloquial sense, Nelson and Britton still owed fiduciary duties. As described in the factual background, the 2019 agreement was an astoundingly one-sided document, stacked with provisions drafted in Nelson and Britton's favor. Every one of the 18 changes highlighted in the factual background should have been called out for the minority members.
Yeah, every one of the 18 is the court's position. That's
Every
strong.
one of them. And so Jackson's claim on fraud, I mean, it's not written in here, but like the court is certainly saying that those should have been noted. At the very least, Nelson and Britton had an obligation to state plainly to the minority members that it was time to switch out of a mindset of fiduciary reliance and into a mindset of arm's length bargaining. They were obligated to put minority members on notice that this was a really big deal.
That's a legal term, really big deal.
Really big deal.
Yeah, exactly.
That was not a chat GPT word this as a kid. These are screenshots. Instead, the New Year's email sought to reassure the minority members and induce them to sign the 2019 agreement. Nelson sent the document on New Year's Eve. That was masterful. Let's see, where is it? That was masterful understatement, and it was hardly sufficient to put the minority members on notice of the monumental changes that the 2019 agreement made to their rights. More importantly, it fell far short of the type of warning necessary to inform the minority members that their ostensible fiduciaries were operating in adversarial arm-length bargaining mode. Those were some big words I wasn't prepared for on tiny script.
What the court's basically saying is that, hey, they needed to let them know that this is an adversarial discussion, meaning that we are trying to change your rights and not in a way that's beneficial for you. And so the court's saying they should have put them on notice instead of just the simple, if you have any questions for us, let us know, or any questions for the attorneys, talk to them. That they should have made it more explicitly clear that they were changing their rights.
Mm-hmm. Purpose of Nelson's statement. Nelson's statement to the minority members was intended to reassure them rather than alert them to any potential concerns, suggesting a lack of transparency in the communication. These are Cliff's notes now. These are my notes. These are not screenshots from the court document. Nelson and Britton did not verbally disclose critical information about the 2019 agreement to the minority members, leaving them uninformed about key aspects of the agreement. Merely providing the 2019 agreement was not enough to meet their fiduciary duty of disclosure. The document was too complex for the minority members to understand without further explanation, which Nelson himself required from his attorneys. So when seeking consent for the 2021 agreement amendment, Nelson and Britton did not provide the minority members with a copy of the agreement, which was essential to fully informing them. Nelson
and Jake,
yeah.
Just to remind the viewers, the 2019 operating agreement changed things, but then there was a subsequent 2021 amendment as well that again changed the geographic scope, broadening the scope of the restrictions. And so there's basically two failures here, independent of each other, that were still not properly disclosed. With the 2020, the subsequent one, they just sent them a signature page for signing. So definitely, again, failing to follow through with those fiduciary obligations of explaining things and making sure they understood.
Thank you you can see right there in those notes how it jumps from 2019 to 21. Those are the two separate agreements. Nelson and Britton misinformed the minority members by claiming that the 2021 amendment did not make any material changes despite the amendment expanding the scope of restrictive covenants. What in the hell again? Good Lord. When questioned about their rights under the 21 agreement, and then confronted with its actual terms, the minority members consistently evidenced shock and surprise about what the agreement said. They did not know from the 2019 agreement all the way up until 21 that the minority members consistently evidenced shock and surprise about what the agreement said. And that testimony came from minority members aligned with Nelson and Aaron and Britton. Even at the preliminary stage, it is clear, as a matter of law, that Nelson and Britton breached their fiduciary duty of disclosures in connection with the 2019 agreement and 2021 agreement. Nelson and Britton therefore cannot enforce the terms of the 21 agreement against Jackson. There's a statute of limitations are generally meant to bar actions for affirmative relief, not defenses. This means Jackson can raise the breach of fiduciary duty as an affirmative defense, even if a similar claim or relief were to be time barred. The purpose of the statute of limitations preventing undue delay to stale claims does not justify suppressing valid defenses. Jackson can use conduct as an affirmative defense, even if the underlying claim would be time barred. So here's some more quotes for you. Sunder has sought equitable relief, enforcing the covenants that it procured through the breach of duty. Jackson is entitled to raise the circumstances surrounding the procurement of the covenants as a defense. John, can you tell me what that means?
Yeah, so the court's not just going to necessarily look at the strict writing of the document. Basically, they're saying here that they want to look at all of the circumstances that are surrounding how they got the signatures on the documents to fully really understand what took place. So that's why the court references the New Year's Eve signing. That's why the court references the use of the attorneys. They reference how this was communicated in emails and things like that. The court's really trying to make sure that they can take a big picture approach to this, which I really think is fair and balanced for both sides. They're not just simply saying, well, you signed this, too bad, so sad. They're saying, well, let's look at everything that took place here.
Let's see. I'm gonna go by these. I don't think they're as important. You guys can read through it. I'm not taking away from one side or the other. It's just legal processes again and definitions. Balanced reasonableness, sophisticated executives. Okay, here we go. So, John, I'm going to let you take this one over. You can feel free to read it and describe what this blue penciling is.
Yeah. So effectively, it appears as though Sunder then they lost at the chancery level, meaning that the court goes, "Yep, we're not going to give you the preliminary injunction. We're not going to do that." And so it gets appealed up to the Delaware Supreme Court. One argument that was raised for the Delaware Supreme Court to consider was something that we call blue penciling. Oftentimes in contracts, you might see something like language that says, well, if this provision is found unenforceable, then the courts can interpret a more reasonable clause and it can be used in its place, something to that effect. It appears as though the Delaware Supreme Court was looking at that, and one of the issues raised on appeal to the Delaware Supreme Court was, should the Chancery Court, meaning that trial level court, should they have simply blue penciled or revised the clause to keep the same general effect of the clause in effect in the contract while stripping the non-enforceable clauses there? That's kind of a simplification of what a blue penciling will be. And so the Supreme Court effectively said, and I believe this is this might be the chancery level, but also it was what was taken up on appeal. But this is what it says. To blue pencil the provision creates a no-lose situation for employers because the business can draft the covenant as broadly as possible, confident that the scope of the restriction will chill some individuals from departing. If someone does challenge the provision, then the worst case is that the court will blue pencil its scope so that it's acceptable. It also enables employers to extract benefits at the expense of employees by including unenforceable restrictions in their agreements. So what the court's basically saying here is that someone could create the most heinously broad restrictive language in a document with the thought process of, hey, if the court doesn't find this reasonable, they'll just strike the parts that aren't, and they'll just reduce the scope or reduce whatever it is that's so heinously unreasonable. Which the court's saying that's not fair, because to the employees or those that are on the other side of the contract, they might just unilaterally say, well, I can't leave, or I can't do this thing because this restriction is so broad that I would be encapsulated by it. And so they just might in their own head say, yeah, I can't breach because, you know, my family might be impacted, or other people, my relatives, my dependents, you know, or I can't work in any state in the United States, whatever it might be. And the court's saying, yeah, no, we don't think that a blue pencil provision creates a reasonable solution or a reasonable answer to resolve some of these contractual disputes that arise.
Mm-hmm. Thank you. All right, so continuing, and for everyone listening here, thank you for staying tuned. We are almost all the way through this, and you will have one of the clearest and cleanest understandings of what is going on and what we're about to find out. All right, so let's see here. Sunder seeks to enforce the competition restriction, but it is not reasonable. Each of the competition restrictions dimensions is astonishingly broad. That's the court's terminology there. The next dimension is whom it covers. The competition restriction envelops not only Jackson, but also the affiliates, defined as any person directly or indirectly controlling, controlled by, or under common control with another person, and with respect to any natural person, the spouse, parents, siblings, and descendants of such natural person. So you guys, listen to this next one here. This is wild. The as written, Jackson's daughter cannot go door to door selling Girl Scout cookies. This non-compete, this whole thing that they wrote up was way too broad for the courts to say, you know what, we can apply that. It was way too much. It even restricts the daughter from selling Girl Scout cookies. That is way too much. And the craziest part, if you remember, is Max was arguing these same things against Legacy, but they're trying to sue Jackson for it. What, are you kidding me? Nelson testified, let me move this over a little bit. Nelson testified that Sunder reasonably anticipates doing business in 46 states. Nelson, the only states that he did not anticipate entering were Alaska, Montana, North Dakota, and South Dakota. Those are beautiful states, but they hold only 1% of American households. Standing alone, those markets hardly represent a fair opportunity for Jackson to pursue his livelihood. Particulars, in other words, those are the states that Sunder is not saying that he is being withheld from. Is that right, John?
Yeah, correct. Yeah, so he'd be allowed to sell in those states.
He'd be allowed to. Thank you for wording that better than I did. Standing alone in those markets hardly represents a fair opportunity for Jackson to pursue his livelihood, particularly when his family lives in Texas and cannot easily relocate due to his daughter's medical condition.
Yeah. So I'll say this is where I have some concerns here. So I'm a father. I got 2 young daughters, and knowing that the contract itself could be so broadly interpreted as to force an individual to only be able to earn a livelihood outside of those states in his career, you know, his chosen career, and to relocate family, especially a daughter with medical conditions. You know, I understand why Sunder might say, well, there's still 6 states here, and you know the court doesn't slander those states. They say, yeah, those are beautiful states, but it's 1% of American households per the court, right? 1% of American households, and the court noting here that, you know, Jackson still needs to provide a livelihood for his family, and he can't easily relocate his family, especially in light of his daughter's medical conditions. Obviously, we don't know what those are, and it's none of our business. But I think that alone should be a red flag to whoever created this contract, that you're going to prohibit somebody from not being able to provide a livelihood and provide for your kids. I think that's pretty strict and overly broad language, in my opinion.
And I take it a little personal, because you can see listed up there, the first state is California, where I happen to live, and I love Girl Scout cookies, and I wouldn't mind if they came to my door and sold them to me.
Well, isn't it
Goodness.
ironic that the court uses that analogy, right? That the clause is so broad and restricted that not even his daughter could go door to door selling Girl Scout cookies. I'm not sure what the attorneys were thinking. They must have been relying on that blue pencil concept, because there's no way that an attorney would think that this would be enforceable, writing this so broadly, at least not in my opinion.
Mhm.
But non-competes still can be utilized. Restrictive covenants still are allowed. They just have to be reasonable. And that's the point that this court is making over and over and over throughout this document, is that these are not reasonable restrictive covenants.
Mhm. Nielsen and Britain can thus make the competition restriction last indefinitely.
Yeah. And you can't have an indefinite restriction. You just can't do that.
Overly broad competition restrictions, like it goes through the list. This is just a pile of words. All of that stuff is just a pile of words and has no bearing or relevancy on any court of law. It's way too broad.
Well, and look, courts look at that, right? They don't want overly wordy things that people don't understand. That people need to understand what they're agreeing to.
Let's see. The competition restriction is unreasonable and on its face and is therefore unenforceable. That is from the court itself. Let's see
And
here. Go
on
ahead.
its face, Jake, so something on its face is a legal term. And so saying something is unreasonable on its face means that, like, effectively, like, this is like abundant or apparently or very easily to see unreasonable. And it's not something that requires complex legal objectivity. On its face, it's unreasonable.
So, having found that Sunder does not have a reasonable probability of success on the merits for its claim against Jackson, the court does not need to consider the other elements of the preliminary injunction standard.
Yeah.
Again, just saying overly broad. Sunder's application fails because there is no underlying obligation to enforce, and because the freedom defendants did not engage in tortious interference with contract under Utah law. Let's see here. Keep breezing past these things, which you all can read as we've stated before. Given these requirements, Sunder's claim for tortious interference cannot succeed. For the reasons already discussed, Sunder has not shown a reasonable likelihood of providing or proving a breach of the 21 agreement. That alone is dispositive. Assuming John,
Sorry.
thank you for that. No,
Sorry. That's just
I love
legal.
That's a friend. That's a friend looking out. Call it legal if you want. Assuming Sunder has shown a breach, Sunder cannot show that the freedom interfered with Sunder's rights by improper means. Okay, so this is just a summary of what's happened. Sunder's application for a preliminary injunction is denied. This decision has been held that Sunder cannot prevail on its claim for tortious interference against freedom defendants as a matter of law, so that path is no longer available either. That is the end of the downloadable documents. There is one document I want you to see. It's highly intriguing and probably paints a picture of the severity of this case.
And
lawsuit.
Jake, before we get into the bond real quick, we just need to briefly address the Supreme Court. So this was appealed up to the Delaware Supreme Court, and the Delaware Supreme Court reviewed everything that the Chancery Court, the lower court, reviewed, and they largely agreed with everything that the lower court found, and said, "Yep, this looks like it was applied correctly. It was analyzed properly." The only thing that the Supreme Court disagreed with was noting that the entire operating agreement was unenforceable as a matter of law. They said that the lower court's ruling on that exceeded the scope of the preliminary injunction motion. Okay, so that's not saying that that the operating agreement is unenforceable, or it is or it isn't. All they're saying is that it exceeded the scope of what that motion was for, what the court was actually reviewing and hearing. And they give lots of reasons for it. Your viewers can obviously look into that. But I do want to note this, right? It says that does not mean that Sunder is destined to lose at trial, but Sunder cannot enforce the covenants as a matter of law or rely on those provisions to secure a remedy from Jackson. And the Supreme Court discussed in how the Chancery Court should have not necessarily ruled on that in the motion that they were hearing. And they said that the court strayed beyond the legal and factual questions presented at the preliminary injunction stage of the proceeding because some of the discovery is more limited and confined to these things. And so while the Supreme Court did say, hey, look, I think that the lower court exceeded the scope of what that motion was for and kicked that back down to the lower level, they did determine that the other points that were raised were still valid and that the court ruled appropriately at the lower level. However, when something gets returned back to the trial level, what's interesting is that both sides have kind of already laid out their position, and the court has kind of already laid out its opinions on the matter. And so even if the matter's to go forward to a trial on those issues, to look about the enforceability of the operating agreement and things like that, I think the court has already done a good job in laying out its opinions of what it's likely to do. And so as a lawyer, if I was representing Sunder or as a lawyer representing Freedom, I would be advising my client on either side of, hey, look, it looks like the lower court has already provided their opinions of what they're likely to do on this. And I would advise them knowing that the court has maybe they did exceed their scope, but they provided us with more information to base our determinations on. That would be my recommendation.
Thank you. And maybe I should have put this bond at the beginning to illustrate what the stakes are for this lawsuit, but here it is right here. There's a $15 million bond. That is a $15 million bond that a company would need to pay. In this case, Sunder would need to pay if found at fault, and if the court decides, hey, it's going to be the full 15 million. It might not be the full 15 million. It could be 14 million, could be 14.5 million, it could be 1 million. We don't know that yet. And that's what we're waiting to hear. You'll also notice on here that 1.5 million was also put into escrow. I am told, I don't know if I'm allowed to say what I'm told. I'm told that that's a personal note from Eric and Max themselves, but the document doesn't say that. I don't know what else it would be, but John,
Yeah,
what is your understanding?
Yeah, Sean, let's mark that. So, Jake, so let me, I guess, briefly describe the bond so you understand. So 15 million is what the bond is for, but this is just the bond in regards to the temporary restraining orders that went into place. So when the court said, all right, Sunder, we're going to give you a temporary restraining order for this period of time, but we want to make sure that if this is improper and it shouldn't be there, that Freedom's operations or these other people's operations are adequately compensated for that lost time during the time in which this temporary restraining order is in place. And so a bond typically works like we know of it frequently from people that go to jail, right? So somebody goes to jail and they want to get out of jail. They call a bondsmith, right? And that bondsmith goes, yeah, your bond is set at $1,500. And for you to get out, you have to pay me at least, $150 of it, or 10%, 20%, whatever it might be. So the court knows, hey, if you decide to run away and you decide to take off to another state or flee to Cancun or something, then the bond company is still going to make sure that the court or whoever the other side of the party is gets that full amount that was ordered, the 2,500 or 1,500, whatever the total bond amount is. But individually, that person paid the bondsmith maybe 10% of that, $150. And that's when we see like the dog, the bounty hunter guys going after and chasing dudes. And maybe that's too old of a show, but they go after him for the balance of the bond. So in this instance, the court determined that $15 million was the amount that should be considered to be a bond, and that 1.5 million of that was to be held in some kind of escrow, by the Chancery Court or by someone for that. So 1.5 million is somewhere being held by someone. That should be fairly certain. The balance of that 15 million bond is what's at stake. And so Freedom or the other side to that bond would have to show, hey, this is what we lost, or these are the damages, or whatever it might be. But something I think is important to consider is that it appears as though Freedom came back after the $15 million bond and said, wait, we don't think $15 million is enough. I believe their demand was 50 million.
50
and
million,
so,
yep.
yeah. And so when we're saying, yeah, any amount of that $15 million bond could be called for, if they were going later for a $50 million bond, I would think that whatever amount is ordered to be paid from this bond is likely near the threshold. Even though the court found 50 million unreasonable and said, yes, hold the 1.5 million, the fact that Freedom actually asked for a $50 million bond, I think places that $15 million at a high risk of being having to be distributed. So that is one main issue of this that obviously I think Sunder's going to have to account for. But there's a lot of other issues as well, right? We're just looking at just the bond in regards to this restraining order. There could be other subsequent lawsuits that get filed, either for Freedom, from Jackson, potentially even other employees. One thing that this lawsuit gave concern to me as a lawyer looking at this is I wondered about some of these unfair contractual policies that were taking place. Like, obviously we know what was taking place with with Jackson and the other co-founders, and so arguably they have a lawsuit. But what about other employees? Were these practices taking place there? Were they concealing employment terms? I don't know. It would give me pause for concern, where I'd want to review whatever our employment policies were. And I'm sure Sunder had an HR team that hopefully advised them well of these practices. But there are additional concerns here besides even that $15 million bond that I think Sunder should be very concerned with. If I was their attorney, would make very strong recommendations to resolve some of these things as quickly as possible.
Thank you, Jon, for going through that, and thank you for hopping on here with us.
You're welcome.
I know that this isn't quite your case, and you came on to make sure that the industry had an understanding of this, because it could affect them if they put things wrong in their agreements as well. And I think that's commendable of you to show up. So thank you for that.
You're very welcome.
Everybody, as we mentioned before, go download these documents, make your own assessment. But there's the way that I see it, and there's the way that an attorney sees it. But thank you for spending the time and going through this. And let's keep our eyes open for what's about to come in May or June.